Hello, my name is James Cole, and today I'm going to be speaking with you about the International Criminal Court, and more specifically about the cases that the International Criminal Court adopts. Our end goal today is going to be creating a model that helps us determine what factors the Office of the Prosecutor considers when bringing cases to the ICC. We start by understanding what the ICC is. It's a permanent international criminal tribunal, and it was created through the Rome Statute. This happened in 2002 when 60 states ratified the Rome Statute, thus bringing the court into action. This means that this is a relatively new court, and it's also a court that prosecutes only the most serious violations of international law. And so this is known by many as a sort of court of last resort. Now we talk about the history of international courts. This is going to help us understand what goes through people's minds when they propose international courts and what factors are important in the operation of international courts. We start with a proposal made by Gustave Moynier in 1872. Gustave Moynier was one of the founders of the International Committee of the Red Cross, and he saw that moral sanctions were unfit to stop atrocities from happening during the Franco-Prussian War. He decided that a permanent international court was necessary in order to stop atrocities, even though in the past he had advocated against a permanent international court. His proposal to the Red Cross to form this permanent international court was denied. Many had worries over states not wanting to sign on to something like this because it would make them lose some of their sovereignty. And they thought that would be unattractive to them. Moving on, we find ourselves at the Paris Peace Conference in 1919. This was directly after the First World War, and there was a desire by the Commission on the Responsibility of the Authors of War and on Enforcement of Penalties to create an ad hoc tribunal in order to try the Kaiser for atrocities that he had committed during the First World War. They argued that lesser crimes should not be tried because that would put too much burden on this ad hoc court. Next, we find ourselves at Nuremberg in Tokyo. From 1945 to 1948, 2 ad hoc criminal tribunals were established. These had expedited trials. In fact, in Nuremberg, trials only lasted for 11 months. And at the end of these trials, 10 of 22 Nuremberg defendants were hanged. Now, there was still a desire after this to create a permanent international court. However, due to concerns over the Cold War, an effort towards creating this international court was shelved. But then we bring ourselves to the creation of the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, which lasted in lifespan from 1993 to 2017. Again, these were 2 ad hoc criminal tribunals, and they had the goal of fighting genocide specifically. And what was focused on here was really responsibility of individual persons. That brings us to the International Criminal Court today, and it was created through the Rome Statute, like we said before. It was voted into creation in 1998 by 120 states, and then ratified by 60 states in 2002, which let it resume operation, or let it begin operations. So now we look at what cases can the ICC take. And this is really going to tell us partially what the Office of the Prosecutor can pursue. Because if the ICC can't take a case, then there's no reason for the ICC prosecutor to pursue a case. And so what matters most here is jurisdiction. Jurisdiction is going to tell us whether the ICC actually has the ability to prosecute a case and be involved in a situation. So one of the aspects of jurisdiction that we're going to look at is territory. So one of these three conditions must be met by the ICC if it wants to prosecute a case. First, a territory in which the ICC wants to operate must be a signatory to the Rome Statute. And so what this means is that if an atrocity happens outside of the territory of a signatory to the Rome Statute, then the ICC can't pursue that, at least for this aspect. The ICC can also go after a case if the perpetrator's home nation is a signatory to the Statute of Rome. And so nationals of states which are signatories to the Rome Statute can also be prosecuted in the International Criminal Court. But thirdly, a case can be referred by the United Nations Security Council to the International Criminal Court, and they can prosecute that way too. And so we have a map here. It's a little blurry, but it gives us generally the states that are signatories and have ratified the Rome Statute. And the green states that we're looking at are the only states that the ICC has jurisdiction over generally. And so nationals from these green states can also be charged in the ICC. So if an Argentinian goes to the United States, even though the United States has not ratified the Statute of Rome, that Argentinian can still be tried in the ICC. And then there's also crimes that the ICC has jurisdiction over. So these include genocide, crimes against humanity, war crimes, and the crime of aggression. Now we'll begin a discussion about what each of these are according to the Statute of Rome. Genocide is killing or causing great bodily or mental harm. It's providing conditions with intent for physical destruction, or preventing births or removing children. And if any of these three are attempting to be prosecuted by the ICC, they have to be directed towards a national, ethnical, religious, or racial group. Crimes against humanity under the Statute of Rome are inhumane acts which cause suffering. These can include murder, enslavement, and sexual violence, though they include more than that too, and these have to be directed towards civilians. The ICC can also prosecute war crimes, and so these are any grave breach to the Geneva Conventions, and on top of that, the Rome Statute includes attacking of civilian populations, mutilating and experimenting on opposition, and also enlisting children under the age of 15 to fight in a conflict. The ICC Rome Statute defines the crime of aggression as an invasion or use of weapons towards another state, blockading another state's ports, attacking another state's military, using military against a state outside of agreements that they've had. So if two states are in an agreement to have a conflict together, then actions that are outside of that agreement are crimes of aggression. And then also giving use of your territory for one state to attack another. And so if you are in the middle of two states that are having a conflict, and you allow one state to use your territory to attack a third state, that's a crime of aggression. And then also hiring mercenaries to do any of the above also constitutes a crime of aggression. Now there are some exceptions to jurisdiction from the ICC too. If the ICC wants to prosecute an individual, then they have to, the state that has jurisdiction over the individual has to be unwilling or unable to prosecute the person. Or they have to have called for the ICC to come in, or the United Nations Security Council must have referred the situation to the ICC. Only people of 18 years old and above can be prosecuted by the International Criminal Court, and only individuals can be prosecuted. States can't be prosecuted, however, representatives of states can. That includes presidents, vice presidents, and other leaders of states. And so, in making a model for what the ICC can prosecute, I'm using the fire triangle as a sort of model for my model. And so the fire triangle shows us that if you have oxygen, heat, or fire in enough quantities in a single space, then fire is going to happen. No, not fire, but fuel. If you have enough of those in a single space, then a fire is going to happen. And so we can have a jurisdiction triangle for the International Criminal Court, which tells us that if a crime is in the jurisdiction of the court, if the territory is in the jurisdiction of the court, and if a case voids the exceptions of the Rome Statute, then the ICC can have jurisdiction over that situation. But what cases will the ICC take? For this, we have to understand the goals of the Office of the Prosecutor of the ICC. The Office of the Prosecutor wants to be effective. This includes responding to gravity, so situations that have a lot of impact in the global arena are important to the Office of the Prosecutor. And the OTP also wants to identify the persons most responsible. And this goes back to after the Paris Peace Conference, or during the Paris Peace Conference rather, the notion of not prosecuting everyone because you don't have the resources to prosecute everyone. The ICC prosecutor has goals of deterrence, and so if they assess a situation and find that their action in it has a likelihood to deter further conflict in the region, then they're also more likely to act in the region. And they also want to manage resources. And this has been a struggle for the Office of the Prosecutor since the beginning, and it's also been a great criticism of the prosecutor that too much money and too many resources are used in the prosecution of these international situations without a lot of results coming back. And so the International Criminal Court, on top of this, has goals of maintaining positive complementarity. And what this means is that the International Criminal Court works together with other states in order to prosecute individuals. This means that the ICC doesn't want to have a situation where they're the only party that's making decisions. They like to work cooperatively with state governments, and that's embedded inside the Rome Statute as well. They also have a desire to represent the interests of victims, and so in that regard, the ICC works towards repairing damages that might have been caused. And they do this in a number of ways. They ask victims for input in cases, and they also have a trust fund for any adverse impacts that actions have caused victims. So using this, we can create a sort of legitimacy triangle with the three pillars that we have shown give the International Criminal Court legitimacy. And I see that there's a lot of glare coming from this. But the blue one here is efficacy, what we just talked about. The red one is complementarity, working with states. So this is how effective the ICC is being. This is how they're working with states. And then on the bottom, we have jurisdiction. And this is how we know that the ICC actually is able to get to a case. And so our model today is that if we can see that the International Criminal Court is going to be effective, if we can see that they're going to be able to work with states, and if we can see that they actually do have jurisdiction over a situation, then the Office of the Prosecutor is likely to take a case like that. So moving forward, I'm working on preparing case studies for SOAR, but also due to recent impacts from the coronavirus, I'm planning on alternatives to SOAR, and one of those alternatives would be creating a second video on top of this that includes these case studies and would likely be a revised presentation with more imagery and would incorporate those case studies into it. So I'd like to thank you for listening to this presentation. I know that there's been a lot of glare on the screen, but I hope that it's been informative, and I hope that once the case studies come in, they'll also give insight into how this model works, if it does work. So thank you.